part of Suso Technologies. So today we have the webinar on DPDP Act, and so DPDP Act. I think all of us are aware about it. So in 2023, the Digital Personal Data Protection Act came into play, and this concept is like not new uh, throughout the world. Like in 1970, the German state of Hesse was basically the first state in the world which implemented data privacy law, and then Sweden actually followed on by in 1973. In India, basically, the ball started rolling in August 2017, I believe. So it was a case between Justice K.C. Puttaswamy versus the Union of India, and then subsequently passing through the Lok Sabha Joint Parliamentary Committee in 2019, and then in August 2023, actually, like it came in as an act. So today we have three distinguished members of our team who would be speaking about the Data Protection Act. So the first talk would be by Mr. Gopal Bhageria, who is our founder, CTO, and managing director. So Mr. Bhageria has uh, like almost for 2 decades, he has been a member of IBM. He is a IBM thought leader and a certified architect. He's also a master inventor of IBM, and he has 40 US technology patents against his name. And he would be speaking on data privacy issues and how DPDP Act intends to address those. Second, we have one of our members, Mr. Debashish Mandal. He has a MTech in computer technology from Jadavpur University, and he has worked on multiple security-related projects for Defense Research and Development Organization. So he would be talking about the challenges of implementing the DPDP Act. And finally, Dr. Anirban Sengupta, who is our cybersecurity practice lead, uh, would be speaking about the privacy legislations of different countries. So Dr. Sengupta holds a PhD in computer science and engineering, and he's also a IRCA certified lead auditor. Uh, so that would be the introduction from my end. Mr. Bhageria, over to you. Thank you.
Okay. Thank you, Devashish, for your kind introduction. So what I will do is I will walk you through, some of the data privacy issues and give a brief information about the Act, right? And Devashish Mandal and Anirban will be covering this in more detail. Okay. So feel free to put your questions on the chat. Okay. So we will collect these questions, and towards the end of the session, we can provide you the response. Okay. So when we talk about data privacy issues, right? The first thing that is that comes to mind is the privacy is kind of a fundamental right, right, to a free society. So, I should be knowing, right? Where my information is being used, right? So, so I should have the control over the information which I share with other third-party companies, service providers, and anyone whom I interact, right? I I expect that my information to be used in the way um, it is deemed fit, right? And the issues are like personal data can be misused, right? If it is not kept or managed properly. And we have seen it in in many places, right? When we talk about say mobile app, right? So there are many applications. Many of them are very, very large corporation. Even they misuse the information which people kind of share, um, and they trusted these companies, right? So it becomes pertinent that there has to be a law, right? That will make these entities responsible and accountable when they acquire the data. So in case of mobile app, I mean, as we all know, right, when we use Android phone, I mean, it gives pretty much the blanket access to everything, right? Whereas in iOS, I mean, there's a little bit better control. But still, I mean, we will see in few slides down the line that uh, information should be used only for the purpose it is asked for, right? I mean, it should not be that you acquire the information and you use it for whatever way you want to use that data for. So there are many such concerns, and to address that, I mean, India has been trying, right? So there was initially IT Act, which at least started talking about uh, how do we protect the personal data, right? I mean, what are the responsibilities and liabilities of entities or corporate bodies who are acquiring this information, how they are managing it, how long they are keeping it, how they are sharing this information, um, and there are many such things. And then in 2008, I mean, there was an amendment. I mean, that basically gave a free right to the government to ban the public access of uh, some of the information which are available online, right? I mean, maybe some website, even we have seen, right, that even the internet access was stopped in many places. And then in 2023, I mean, this became the act with a little bit more detailed, right? And then in 2025, I mean, there is a rule and government is seeking some comments. And we also provided our comment back to, I mean, back to the government, right, through NASCOM. So, okay. So I mean, this I think we have covered. It became legislation, and in 2023 and 2025, there is a more detail that has been added, and the protection rule and other information, and it is being asked for the implementation, right? And that is where uh, I mean, we have experienced that that is the crux of the whole thing, right? I mean, you can have like whatever law or act you want to create, but if it is not enforced or not implemented, right, then it is of no use. So where DPDP Act is applicable, this personal data collected online or even offline, right? I mean, in the form you are collecting certain data. Even though it is called digital protection, right? But still, I mean, it applies to even the paper data, which is usually digitalized, right? Processing in India, regardless of whether data belongs to an Indian citizen or foreigner, processing outside India data, if it involves offering goods or services to individuals in India, right? And it doesn't apply to anonymized data, right? And non-personal data. So there are, I mean, certain principles around which this act has been designed, right? So it's a lawful and transparent use. So data must be processed with clear purpose and consent, right? If I provide my data for a specific purpose, like somebody is offering me a service, then they should use the data only for that service, right? To provide me a better service, they can use that data, but they cannot use that data to do other acts. And obviously, I mean, there is a purpose limitation. There's a data minimization, right? I mean, this is where I was talking about that mobile app. I mean, if you are serving me some information on mobile app, probably you don't require the access to my contact list, right? I mean, why do you need who all I have in my contact? So so there has to be this DPDP Act follows these principles that data should be minimized. Obviously, accuracy and accessibility, right? There is a storage limitation, even though the Act has not provided specific duration. for which the data should be kept, unlike many of the other acts like SOX and other acts where they have very, very specific guidance around how long you need to keep the data in your organization, and then the security safeguard, right? How do they ensure whatever data you collect, it is managed in a way that it is not breached, right? I mean, we have been hearing it. Even, I mean, recently there was a news that even some places Aadhaar data was breached, right? So these are very, very serious concern. And that's why, I mean, there has to be accountability of the organization, I mean, who are uh, using the data. And you must know that when we talk about, say, credit card information, I mean, for credit card, the PCI compliance, right? I mean, that made it so complex that, I mean, most of the people, most of the companies, they stopped actually collecting uh, the credit card data, right? Only few companies, I mean, who can comply and abide by the act. I mean, only they basically store your credit card data, right? And even the recent guideline from RBI, even that is prevented, right? So, so when act is designed, I mean, these principles are followed in defining the rules. Okay. So the key features, so DPDP Act protects digital personal data by providing rights and duties of data principal. We'll talk about these technical terms like data principal, data fiduciary, and then the board, etc. Okay, and there are penalties and guidelines that is defined in the rule. So, so I try to just capture this um, in this diagram to show uh, how different entities kind of interact and what are the responsibilities of um, each of these entities, right? So when I talk about data principal, so data principal is a person whose data is under consideration. So if I am the user of a mobile app, right? So I become the data principal because my data is shared with the mobile app um, application provider, and that service provider becomes the data fiduciary, right? Because he is basically utilizing the data I provide, right? So data is shared with this company, and then I can have a specific consent, right? Like, like, I mean, you may remember, I mean, there was um, uh, a telecom registry, right? Where, I mean, you could go and register that do not call. So that means do not call for any marketing purpose. And this data fiduciary has to comply with my consent. So this consent can be managed by a third party company, right? So there may be like in case of telecom, it was Try, right? And then similarly, there can be other consent manager who will manage the consents of uh, individual principals, so data principals. And if there are say data breach, right? If there is a data breach, then that has to be intimated back to the principal as well as to the data board. So data board is a government designated authority who is basically uh, kind of doing the oversight and governance of the implementation of the act, right? Similarly, I mean, if there, so data protection board has provided guidance and all for the consent manager, and there is another entity which is called significant data fiduciary. So these are the entities who has a lot more information about the individual person. Just a second. and they own a lot more sensitive data, right? I mean, say in case of India, the Aadhaar, like so the Aadhaar data, right? I mean, so that entity is UDDI is a significant data fiduciary. Okay. These are some little bit more information. What are the rights of data principal? Know how their data is used, request update or deletion of their data. So if I provide the data, it doesn't mean that the other party can use it as long as they want. I mean, I can request them to remove the access of my data, right? Provide and withdraw consent. So I should have the ability to give my consent for a certain period and revoke that, right? And then if there are issues, then I go to the board for grievance redressal. Okay. Similarly, there are a number of obligations of data fiduciary, like I mean, they should check for explicit consent, provide notice about the data usage, implement security measures so that there's no breach, right? And then they can use the consent manager service. And if there are any breaches and all, I mean, they have to also report it within a time frame, right? It's not that a breach happens today and they are reporting it after 1 year, right? And then obviously for significant data fiduciary, I mean, because they have access to a lot of sensitive data. So there are, I mean, additional regulations, right? I mean, they need to appoint data protection officer, appoint independent data auditor, right? Conduct data protection impact assessment, and then perform regular audits. Of course, I mean, there has to be additional safeguard for children, I mean, who are less than 18 years of age. So there are parental consent that has to be captured, as well as protection from harmful practices like tracking the children, right? And then uh, doing the behavioral modeling, etc. I mean, especially like, I mean, when there's so much going on online, right? I mean, I was just reading about it just yesterday, that say Geo Cinema, right? I mean, they are broadcasting all the IPL matches, and there are a lot of kids who are watching this, and many of the behavior of the kids are being tracked, and they are even mapped, right? So with these acts, I mean, it will provide additional safeguard to children and ensure that the data is not misused. Okay. But there are exceptions, of course, for government agencies, research, and the employers, right, who needs to verify the background and other data for employee without consent. And there are like a lot of penalty details and all they have captured. This is just to prevent breaches to happen. And so, yeah, I mean, if you're playing any of the role, I mean, you need to ensure the compliances and follow the practice. So yes, I mean, it is still a long way to go for India in terms of implementing the act, but it's in the right direction. Okay, so let me conclude. I think I took probably a lot more time than I was given. Sorry about that, but yes. So as I think next Devashish Mandal.
Yes, the next
Yeah.
speaker would be Devashish.
Yeah, I'll
Thank you.
just go ahead and share my screen. Thanks. Is my screen visible?
Yes, it's visible.
Okay. So, in this part, we are going to discuss the challenges that we may face while implementing the DPDP Act. So, with the DPDP Act 2023, India has really introduced a strong legal foundation for personal data protection. For the IT and security teams, this means revisiting how data is collected, stored, shared, and deleted across the systems. So we discuss about the various challenges that surface during the implementation of the DPDP Act 2023. It can range from ambiguous scope and definition and cross-border flow restrictions to implementing consent workflows and handling children data, including impact on the startups. So for many SMEs, complying with the DPDP Act is a significant challenge due to their constrained budgets, limited IT infrastructure, and the lack of specialized personnel. So this makes it difficult for SMEs to implement the kind of stringent ongoing controls required by law, particularly when they handle like a huge customer or employee data at scale. Now, meeting the requirements of the DPDP Act may involve like upgrading the IT systems, purchasing compliance softwares, training staff, etc., and like to maintain or rather to meet the privacy standards. This could divert the funds from other critical business operations, making it a significant financial strain, particularly for the small to medium enterprises and startups. Now, uh, there is no separate category for sensitive personal data mentioned in the DPDP Act, like we have in global laws like the GDPR. So here the organizations may have to struggle to prioritize the protection efforts because there is no clear boundary of whether all the types of data need to have equal treatment or not. A clear procedural guidelines, defined exceptions and conditions, templates or standards, consent language, and security controls need to be in place. Until such clarity is provided, both the data principals and data beneficiaries operate in uncertainty. That in turn increases the legal and operational risks. The criteria of being designated as a significant data fiduciary are yet to be concretely defined in the DPDP Act. The Act only mentions that the government may classify organizations based on certain factors like volume and sensitivity of data processed, the use of new technologies, etc. Now, until these criteria are clearly communicated by the government or the data protection board, companies, the companies which undertake practicing the DPDP Act will be at, I mean, the practice will be rather risky and inefficient compared to if we have these clear definitions of the significant data fiduciary and other terms. Okay. The DPDP Act really allows transfer of personal data outside India, but it is limited only to the countries that are notified by the central government as acceptable destinations. Now, as of now, we do not have any official list of permissible countries that has not yet been released. So this leaves, this rather creates a gray zone for the regulatory authorities for business. And like there may be the multinational companies are there, they may need to restructure their data architectures, limit their storage or processing to India only or to the allowed jurisdictions. They may also be forced to set up localized data centers, significantly increasing their costs and overhead. And one more thing which may come up is that they may also they may also require contractual changes with global vendors or partners just to ensure the new compliance. And like they may also need to reassess their own internal and external policies on data handling across across certain regions. Moving on to Yeah. Now, most platforms will process multiple data points for multiple purposes. So, as the DPDP Act mentions that we should be taking consents for particular purposes and the data should be used for that particular purpose only. So, it makes it necessary to split the consent requests for each purpose. Now, this makes the process a bit operationally intensive because, to implement these things, the significant changes in maybe backend architecture or data tagging may be required for the existing platforms, especially the legacy systems. The Act also gives individuals the right to withdraw consent at any time. And once the consent is withdrawn, the organizations must cease data processing. So, in order to enable these functionalities like deleting the data or seizing the uh, processing of the data, the companies must create dashboards or self-service portals or consent management portals and maintain a detailed audit trials to ensure data minimization. Now, all these requires, I mean, it requires a significant investments for the small and mid-sized firms. So that itself is a challenge to the small and mid-sized firms. Coming to data portability uh, and data eraser tools, under the DPDP Act, the data principals have the right to request erasure of their personal data when they no longer need it or when they withdraw their consent, right? So organizations must identify, erase, and confirm the deletion of the requested data across all their systems. I mean, data is actually not, it's not always that data is stored at a single place. It is often distributed across multiple databases, backups, third-party platforms, analytical tools, etc. And one more point that we come up here is like some systems even lack the native support for deletion, especially for the legacy systems. So enforcing the data eraser requires investments in data discovery tools, automation tools, etc., which is again resource intensive. The DPDP Act gives users the rights to obtain and reuse their personal data by requesting it in structured, commonly used, and machine readable formats. Right. So, but there is no standard template or data schema defined by law for portability. And again, the interoperability between the platforms is also limited when we deal with the legacy systems. This poses a challenge for service providers, like who need to design export tools and APIs that are compliant and user friendly as well as secure. Uh, yeah, like in many other cases, here also we have a concern regarding the lack of awareness with this law. Most of the end users are not aware of the rights or they do not understand how to exercise them effectively. They lack the awareness of about what data is being collected, how it is being used, how it is being shared, or what rights do they have and how do they assert them. Like and we also see like many users, they blindly accept their consent requests without even understanding the implications. And that is where the purpose of the meaningful consent is defeated. This leads to underutilization of the safeguards and creates a false sense of compliance among them. Without adequate training of the employees, there is a risk of accidental violations, non-compliance penalties, and loss of customer trust due to mishandling of the data by the employees. So this is also sort of lack of this points out a sort of lack of awareness among the employees of the organization. Uh, One major point is like the DPDP Act places special emphasis on protecting personal data of children. The DPDP Act in India defines children as an individual usually under 18 years of age. Now, to comply, the organizations must verify the age of the users and apply specific safeguards. The age verification methods, that may include like uploading official identities or like doing biometric checks. They can in turn be intrusive because they they can be sort of potentially violating the privacy because I mean we are asking for additional data from the users. So I mean this creates a sort of compliance dilemma, right? How to verify age without over collecting data or harming the users. Now, one more thing is there that the companies must obtain a verifiable parental consent before processing any personal data of the children. So, question here that arises or the confusion that here that may arise is like how do the platforms verify if the consent giver is actually the parent or the guardian? And one more case that could come up is like when the child turns 18, or rather he is no more a child and becomes an adult. So we need a procedure to like transfer the or revoke or migrate the previous consents given by the user as a child. And one more point is that there is also a risk of non-compliance if the platforms unknowingly collect child's data without proper verification of consent. Right? So these are certain factors which adds another layer of complexity to the age verification process in the DPDP Act. So impact on the startups or small size companies would be like stringent compliance requirements for the DPDP Act can create a high compliance burdens, like especially for the early stage startups or innovative tech ventures. Now, the lack of resources for the startups and the fear of heavy penalties. These are like some of the discouraging factors for startups, which create sort of compliance versus innovation tension. So, yeah, and then the sectors like artificial intelligence, fintech, and e-commerce, they rely heavily on the large-scale data collection and analysis to train AI models. They provide personalized recommendations and detect fraud or automate decisions, etc. Now, under the DPDP Act, all data usage must be purpose specific and consent based. And the frequent withdrawal of consent by the users may disrupt the model training, analytics, and continuity. Like because we know that according to the DPDP Act, the users can withdraw their consent at any point of time. So this may lead to product inaccuracy because I mean the training data set gets distorted and that way the accuracy of the product may be affected or be limited, and it in turn increases the operational costs due to continuous revalidations of the user permissions. To conclude, I would say that the successful implementation of the DPDP Act depends on three things: the clarity, scalability, and support for all the stakeholders. Stakeholders include the organizations, consumers, regulators, and service providers. To achieve this, several measures must be taken. Like current rules and definitions need to be more specific, especially regarding the classification of significant data fiduciaries, sensitive or personal data, and the rights and responsibilities of the data principals and data fiduciaries. For the organizations, especially the digital platforms, should be encouraged to implement automated consent management systems. Nationwide awareness campaigns should be conducted to educate consumers about their rights under this act, and also training and certification programs for employees should be conducted to handle like personal data across the industries. Clear guidelines on cross-border data flow must be established for the global firms, like sector-specific guidelines also need to be in place so that organizations are helped to interpret and apply the rules accordingly in context. Develop simple compliance playbooks tailored for startups and small organizations. Where they lack legal and technical expertise. This can be done by offering them templates, rules, and sandbox environments, etc. Standardized frameworks for data erasure and portability need to be, need to be developed. This would reduce some technical ambiguity. The standard frameworks for child-safe designs and age verification protocols that protect the minors from overburdening platforms need to be in place. And lastly, the organizations should strengthen themselves with increased capacity of the resources and expertise in order to flourish in the implementation of correct implementation of the DPDP. So yeah, uh, I think that would be all for from my side. I'll stop sharing this.
Yes, thanks, Deva.
Thank you.
Yes, so the next speaker would be Dr. Sengupta. If you can please share your screen.
Yes, is my screen visible?
Yes, we can
Yes.
see you.
Okay.
Yes.
Okay. So good afternoon, everyone. So now that we have understood more or less the provisions of the DPDP Act, let us look at the data privacy legislations that exist elsewhere in the world. Now, it's important that if an organization chooses to carry out its business in a particular territory, in a particular country, then it should comply with the data privacy legislations of that particular country. Now, finally, India has its own Data Privacy Act, the Digital Personal Data Protection Act that we have already looked at. And only thing is, it has not yet been implemented, though it has already been passed by the Parliament of India in 2023. That's because the draft rules have been published in January 2025. And the rules are now being debated and discussed in various forums. We have also, as Sir said, we have also provided our suggestions. So once the rules have been finalized, the DPDP Act will be implemented. Now, interestingly, the GDPR, that is the General Data Protection Regulation, that is valid for the European Union, that serves as the mother data privacy legislation, if I may put it that way, for the entire world. Because whenever any data privacy legislation is formulated, more or less GDPR is referred, and the provisions of the GDPR are adopted to suit the country's specific privacy needs. Even India's DPDP is based or is inspired by GDPR. Of course, there are some minor differences. For example, we talk of data principle, whose data it is. So it's the data principles data. In GDPR, the term is data subject. Then here we talk of data fiduciary. In GDPR, it is referred to as a data controller. Again, GDPR doesn't have any concept of significant data fiduciary. That's an innovation that DPDP has. It also doesn't have any consent manager for that matter. Another interesting difference is for data breach notification. So if there is any data breach, immediately, as per DPDP, immediately law enforcement, that is the Data Protection Board of India, needs to be notified, and the affected data principals also need to be notified. In case of GDPR, there is data breach notification within 72 hours. The notification has to be done, but there is a risk threshold. That means if risk crosses a particular threshold for that particular data breach, only then you need to notify. Otherwise, notification may not be required. Okay. Then in case of children, children's data, DPDP defines children's age as 18 years. So anyone under the age of 18 is considered a child. In GDPR, the age is 16 years. Okay, and for some member states of the European Union, the age is 13 years. So that's a major difference. There are some minor differences, so to say, in almost all other privacy legislations. Now, Australia's Privacy Act, this is one of the early data privacy legislations that was enacted in Australia in 1988. So the original act covered only government entities, and later there were amendments which also covered some commercial entities. And the Australian privacy principles, there are 13 of them. Those were incorporated later in the act. And there have been some recent amendments 3 or 4 years back where the penalties were increased and the rights of the Office of the Australian Information Commissioner were also enhanced so as to be able to implement the provisions of the act better. The 13 Australian privacy principles are more or less, they more or less comply with the principles of DPDP also. For example, you have provisions regarding anonymity and pseudonymity, then accuracy of information, security of information, then you have openness and legal processing of data with the help of consent from data subjects and things like that. Now, USA has 4 types of privacy acts, if we may put it that way. Okay, so CCPA is pretty recent, the California Consumer Privacy Act, and along with that, the CPRA has also come out. That is the California Privacy Rights Act. Both together are concerned about the privacy of people who reside in the state of California. Now, any business which carries out business transactions in the state of California need to comply with the provisions of CCPA. So people have the right to know where their data is going, how it is being used, how it is being shared. People have the right to opt out of the sale of their data to other parties. Okay, then people have also the right to get their data deleted, their personal data deleted. And CCPA allows cross-border flow of data. Another interesting point in CCPA is it's not only about individuals' data, is they also talk about, and the Act talks about data of households, household spending pattern, okay, buying pattern, and things like that. So those are also protected information. We have HIPAA, Health Insurance Portability and Accountability Act, that was implemented in 1996. So this is concerned about PHI, protected health information, that is identifiable health information. There are 3 specific rules in HIPAA. The first is the privacy rule, so which tells that health information or health records of people, according to the Act, any healthcare organization should maintain the privacy of such healthcare records. The second rule is the security rule. It tells that the confidentiality, integrity, and availability of PHI should be maintained. And the third is the breach notification rule. So whenever there is a breach of PHI, law enforcement should be informed, and the affected data subjects also need to be informed. So this concerns healthcare organizations, healthcare clearing houses, health plans, and things like that. The next Privacy Act in USA is the GLBA. This concerns financial organizations, the Gramm-Leach-Bliley Act. Now, here also there are 3 rules. The Financial Privacy Rule, which talks about the privacy of financial data. The Safeguards Rule, which concerns the protection of confidentiality, integrity, and availability of financial data during the entire data lifecycle, during the collection phase, processing, storing, sharing of data, even deletion of data. So security has to be maintained. And the third one is very interesting, the pretexting rule. So using false pretenses, financial data cannot be collected. So this has now become the norm. We always receive phone calls or emails, SMSs from people saying that your KYC has expired. So please share such and such information so that it can be renewed. Otherwise, your transactions will be put on hold. So once we share those information, we share the OTPs, all our money is gone. In order to prevent such cases, the pretexting rule had been introduced in GLBA. So it talks of access controls, a lot of other security controls also. Then there is COPA, Children's Online Privacy Protection Act. Now, child is defined as someone under the age of 13 years as per COPA. So if any website or online service provider needs to collect private data of children, personal data of children, then verifiable parental consent is required. Now, parent here includes legal guardians also. So there are some cases where consent may not be required. For example, one-time service has to be provided to the child, and the child's personal information won't be stored in a retrievable manner. In that case, consent won't be required. Otherwise, consent is mandatory. That too, verifiable consent written. Canada's PIPEDA, Personal Information Protection and Electronic Documents Act, this is similar to GDPR. There are some differences. For example, the right to data portability is not there, as Debashish was talking about right to data portability as part of DPDP. But Canada's PIPEDA doesn't have the right to data portability. Also, the right to data erasure is also not included in PIPEDA. Then there is no distinction between data controller and data processor. Okay, so it's considered as the same, just mentioned as an organization handling data. That's all. So there are some differences. Again, children's age has not been specifically mentioned in PIPEDA. Other things are similar to GDPR. South Africa's POPIA, South Africa's Protection of Personal Information Act, POPIA. Now, this was actually formulated before GDPR, but there are a lot of similarities. There are some differences. For example, this concerns data which is processed within the territory of South Africa. But in most other laws, most other privacy acts, along with the data processed within the territory, data processed outside for providing services or products to people within the territory of that country, they are also, under the ambit of the privacy law of a country. But in POPIA, that's not the case. It's only about data which is processed within South Africa. Okay, and sorry, cross-border flow of data has not been considered here. So that's another important point. The age of children is like India's. So it's 18 years of age that has been considered as the age of children. Below 18 years, you need parental consent. Okay. China has a data privacy law called the Personal Information Protection Law that's quite stringent. They have classified data into two categories, sensitive data and more sensitive data, or data which has greater sensitivity. So children's data comes under that category. Children over here, again, the age has been set as 14 years in case of China. Then healthcare data, financial data, those are more sensitive data. Now, in case of data which is more sensitive, personal information protection impact assessment, that is mandatory. Now, for example, we have data protection impact assessment in DPDP, okay, or privacy impact assessment elsewhere in GDPR and elsewhere. So similarly, they have personal information protection impact assessment that is mandatory in PIPL, okay, and cross-border flow of data is allowed, but China reserves the right to blacklist countries which do not follow proper data privacy principles. So there, the data cannot flow. Personal data of Chinese citizens won't flow to those countries. Malaysia's Personal Data Protection Act, this is again like GDPR. There are two differences. Data breach notification, there is no provision for data breach notification over here, interestingly. And cross-border flow of data is also not encouraged. Yes, there is some exception, like if a minister in charge signs a document, then maybe cross-border flow of data will be allowed, but they do not encourage it under this act. In case of Singapore's Personal Data Protection Act, cross-border flow of data does not exist, but they do have a provision for data breach notification. But like GDPR, that's graded, there's a risk gradation. So if the risk threshold is crossed, then you need to notify the breach to authorities as well as affected data subjects. Then there is no right to data erasure. There is no right to data portability in Singapore's PDPA. And the age of children has been fixed at 13 years. And like China's PIPL, here too, data has been classified as less sensitive and more sensitive. So more sensitive data requires more stricter controls. Thailand's PDPA is almost similar to GDPR. Only thing is children, there is no specific definition for children over here. So the age is not known. Only in one particular provision, it has been mentioned that anyone under the age of 10 years, if you need to collect their personal data, then parental consent will be required. But specifically, the term child or definition of children is not there. So we looked at some of the data privacy legislations around the world. Interestingly, most of them derive their provisions from GDPR, and there are a lot of similarities with GDPR. So if one goes through the provisions of GDPR, you will more or less understand the principles, the basic principles that are followed across the world in case of data privacy. Yes, of course, there are some minor differences. So if an organization needs to carry out business in multiple countries having different data privacy legislations, then those differences must be considered. Thank you. I'll end my presentation here.
Okay. Thanks, Dr. Sengupta. I think now we have the forum open for question and answers. If anybody has a question or a comment, you're free to discuss that. I know we are already like over 10 minutes, so
Yes.
we can quickly take one or two questions.
I may add a point that if you need to comply with the provisions of DPDP, if you, of course, there are a lot of steps involved, like you need to formulate your policies accordingly. So once the rules have been published, the final version of the rules, that is, the DPDP Act will be implemented, and that is going to be sooner than later. Now, if you need to formulate policies accordingly, if you need to perform data protection impact assessment, then you can always get in touch with Sujosu. So we are in the domain of cybersecurity and data privacy full time. You can get in touch with us. We'll be ready to help.
I think we do not have any questions.
Okay.
Yeah. Gopal sir, if you
Okay.
want to.
No, I
Closing
mean, I would certainly like to thanks everyone for joining the our this webinar session, and we will be conducting more webinars. I mean, cybersecurity space as well as other AI and application development, modernization, data area. So we plan to conduct multiple sessions when we continue to look forward for the support. So thanks Devashish Basak for joining. If you want to introduce yourself, Devashish Basak, and if you have any question, you can ask.
Yeah, sure. So this is Devashish from Nomura. I'm with this organization almost 20 years over here, and heading the ITS department, and having three kind of tracks over here. That is the system administration and data center. The responsibility. Second one is SOC support, as well as the third one is the production support. So heading all these three tracks, and Nomura, I think everyone knows a little bit more. So it's a renowned organization, mainly focusing on the capital market domain and also having a footprint across the world. So that's it overall from the Nomura and
Great.
side. And definitely, yeah. So I have invited through Brishti Mondal, who is our HR head over here, and she mentioned that I should attend this one, and definitely in future we maybe continue with this DPDP Act implementation, and definitely will be in touch with you soon. Yeah, so that's it.
Okay.
Yeah. Thank you.
Thank you.
Okay. Yeah. I think we can conclude the call, but
Yes.
thank you, everyone. Thanks, Anirban. Thanks,
Thank you.
Devashish.
Thank you,
Yeah,
sir.
thanks.
Devashish.
Thanks, everyone.
Yeah.
Okay.
Thank you.
Everyone,
Thanks,
you.
everyone.
Thank you.